the broken baker, where crimes are baked in every show. Mysteries rise and truth unfolding. Ready, set, it's time to go. We say it's time to go. Whistling through battering news, mixing stories, solving the lies. In this kitchen, secrets are broken. With a spark in our eyes. In the broken baker's kitchen, the secrets crumble, lies don't rise. We'll sift the clues, defy the moves. With a spark in our eyes. The broken rise. Broken rise. Welcome to the broken baker. Get ready. Let's go.
I'm Jimmy. How y'all doing?
The most important people in this case that everybody seems to have forgotten in this room is the jury. So we're going to take a 15-minute break and both sides take a pregnant pause and think about the jury.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any you might be. And welcome to this Rule 17 motion hearing in the Karen Reed case. But Baker, you ask, what is this about? Rule 17. Well, it's about the new Master Assistant ADA, Mr. 75,000, wanting to have Karen Reed's father's phone records, Karen Reed's mother's phone records, and they want something from the press again. The stuff from the press we already had in the first trial, where NBC said, that's fine. We're going to send our corporate lawyers. They said, okay, we're not going to touch that. They filed the motion for the wrong office at NBC. So I don't know if that's going to be part of it today. And I don't know if you use the same Cellbrite in Camerica as we use in Denmark. But why do you want her father and mother's phone record? Because the Cellbrite report will show every ingoing, outgoing call on Karen Reed's phone. And remember, from the first trial, we know she didn't delete anything. Other people did. Jen deleted a lot of things on her phone, which didn't show up until the feds did their extraction, because Trooper Guarini can't find his own ass if someone is not pointing to it. The man who didn't see how many thousand of messages in the Sandra Birchmore case couldn't find deleted messages on Jen's phone. So it's going to be interesting. We have a lot of outstanding rulings from the last meeting. I don't know if Bev is ever going to rule on anything. Will she delay the trial to the 1st of April? We don't know that either. But it's going to be interesting to see what's going on today. What's the media thing? The same as they wanted the last time. Unaired video from the interviews with Karen, because they have a theory, and you can see the Smurf talk about it all the time. Well, she admitted she did it, but she didn't. If you hear what is actually said in the interview, it's her father talking, and if you clip it the right way, yes, it could kind of allude that she said, I hit him, but that's not, when you hear it in context, that's absolutely not what is said. It's more, it's fishing again. But it could be interesting to see if we're going to get a ruling if they can have the Morrissey personal email and his iCloud account. Hey, Stephen. This aggression will not stand, man. I'm mellow. I'm so mellow, I'm almost yellow. Hey, Jemima. And Jamie. Jamie's working too. That's why she's not here. And from Holland is here. Shark and Ha. Exactly. But no, again, it's more of the same. They had. How long did we do the case? It wasn't 8 weeks. Was it 9 weeks we ran the case to begin with? Plus a year before that with motions. We had the last hearing 3 weeks ago, 2 weeks ago. And he wasn't even prepared to have his own Rule 17 motion. He didn't know he should call witnesses. That super lawyer that they called in because Lally couldn't be trusted to run this case again. But Lally has to sit like a schoolboy next to him and watch him do his thing. If I was a taxpayer in Massachusetts, I would ask for a rebate. Hey, Eddie and Peter and Mr. Fett and Corona Mountain Mom. JVH. Took long enough. I was on early because someone was crying. Oh, no pre-show. I can't do anything. But no, it's just more the same. It seems like they forgot they already had a trial. They forgot that they already filed most of these motions. They want to use all that stupid stuff again that they used the first time, that calling a lawyer is implicit guilt. No, it's not. It's totally fine to call a lawyer. It's the Sixth Amendment, if I'm correct. You have the right to legal counsel, which doesn't mean a lawyer, but just means someone should counsel you on the law. But they want to imply that by calling a lawyer when some police officer is calling you, which you should always do. The first thing you should always say to the police officer is, I don't want to talk to you without my lawyer present. That's the first rule of Lawyer Club. So, but using that to imply guilt is so stupid. And now saying she might, what they want to imply is she called her, I can't even remember if the mom or the dad, on the night while she was at John's house with the kids when he didn't came home, and she was angry. That because she then called her parents, she's guilty. I don't know how their relationship is. I hope when my girls are in their 40s, they're going to call their old man if they have something they want to talk about. I know my sister did it when the last time we were out drinking in my town when she was home and my dad was still alive. She called him at 4 a.m. to get him to come pick her up and said, let's take a cab. Nope, I'm going to call Dad. And he came and picked her up from, well, I took a ride home too, but I have never been able to do that. I think it's a girl thing. Yes, but this is a good Christian channel. Not only that, the MSP has already taken legal action against her by having her section. Yeah. So again, why wouldn't you call a lawyer? And I know the Smurfs, because they are idiots, and all of them more or less is embroiled in multiple lawsuits. They don't get that you should always have a lawyer. They can't afford one, but they should always. You forgot the new prosecutor has an annoying voice too. Yeah, we thought Lally was annoying. Oh my. Well, she called her mom. Yeah. But again, if you get mad at your boyfriend and you have had, and let's be totally honest about that. We saw the text messages that day. It didn't seem like he was mad. She wanted a plumber to come by, and I know the Smurfs are implying, well, she effed the plumber, but it's if she got mad that he went in drinking, as I hypothesize, Jamie, like I said, what I think happened was he said, "I'm just going to go in and say goodnight," because we saw the rhinos square up and point at him. So maybe he wanted to go in and say, "Hey, buddy, this is done," and he didn't come out. And she thought, "Well, that idiot is out drinking again, and he's leaving me with his kids." Yeah, maybe I would call my mom and said, "Can I just leave the kids?" I don't know, especially if you don't have kids. Hey, Jess, pardon the swear, but this is other BS. It is. Ladies have it too easy. Yeah, probably wouldn't do that. But I do know a good few lawyers, so I can recommend you one. Yeah, I've been missing that crotch shot. Thank you, Jess. But we can see his bald head. He's so bald he could be a police officer in Canton. Yeah, it's such a BS move, and it's so easy to do online where you just go and say, "Well, I would never do that." Well, you haven't been targeted by the police. Yeah, just to complain and talk about everything. It's a lot of pink. Yeah. Oh, they don't have a cordon around it. I don't think horse milk is a misdemeanor. Hallo, Schöne. Geht's dir gut? Nothing comes without the grift. But no, I wasn't impressed with Mr. 75K in the first trial. So hopefully he's better prepared this time. Why do you say yes to a job and then don't prepare for the hearings in that job? Again, I would be mad. I would be mad if my taxpayer dollars went to a guy who is that incompetent. But in Massachusetts, everything goes. Hello, Regina. Well, it's education. We did have a children's show once where one of the segment was guess a turd, where they showed an animal turd, and then you should guess what animal it came from. Wasn't impressed with Brennan. No, he. I know he's a big shot, Mr. Whitey Bulger, but he's not doing that well. I saw three Smurfs outside. Aiden was interviewing one of them, and she didn't. She didn't seem like she knew anything about the case. Hey, Dan. Hey, Sammy. Kimberly. You don't want to see his nasty mug? Well, I can turn my camera off. The one who showed the turds? No, that was kids' TV. It's a Rule 17 motion about her parents' phone records. Yeah. Aw, you're sweet when you're lying. I love that everyone is spurting out that, oh, she had a party this weekend and she was drinking. Shouldn't be allowed to drink when you have been accused of drunk driving. Then none of the cops in Canton should be allowed to do anything. I think she will take it under advisement, as always. We will get a filing later. Hey, Mr. T-Rex. Well, she is charged with a DUI. I mean, the charge 2 isn't that being under the influence charge 2? They should. Yeah, again, if she was on bail with conditions, yeah. If she was made to do testing every week, fine. But she doesn't have bail conditions. It's so stupid. Yeah, Paul O'Keefe, who slammed into a guy while he left the golf course drunk, but no problem with him drinking. They won't. We said that already before the first trial started. They won't get another one. You have to ride or die with Bev. The only thing you have to do that I feel they maybe have to focus on from the defense is they need their experts to be better to explain the facts. Not the ARCA guys were good, but and this time they will have more time to prepare Dog Bite Lady. I liked her, but I'm not sure she got it over. But they need a new tech guy. The tech guy wasn't good. He was way too smart, and smart people can't talk to dumb people like me. Hey, Lally. Imagine having to sit next to the guy who got your job and just sit there and say nothing. It's like holding your camera while your wife is having smacks. Yes, it's one of the charges is under the influence. If the defense was smart, they would totally drop the idea that she was framed and focus on the fact that the series story makes zero sense. The third-party culprit could work, but they will have. If I was them, and now they have the jurors reach out, I would have to figure out how did they take that. Should we totally skirt away from that and kind of allude to it, but let the state waste just as much time trying to protect the McAlberts and then absolutely don't talk about it? I could do that. Yeah, that's the circular logic. No, that trooper that someone claimed was clearly thrown out of the job haven't been fired. He's in a union. He can't be fired easily. Yeah, and he's sitting there again. It's like
If possible, yes, that would be great.
they should remember to turn off the defense's microphones. Yeah, they will be calling him a meteorologist. No, she hasn't, but it's an underlying fact that while drunk. So to prove it, they have to prove that they have to believe she was drunk. Oh, the Clara is in court today. Yeah, but there's so many things they claimed in this case that never came true. No, well, we can only kind of assume they're going to use the same tactic, but let's see where they're going. Hey, Dream. It's nippy. Yeah, it's cold here.
When did they file our motion? What did you say?
MLS just ruining everyone's day. Remember one of the attorneys talking about Proctor would be kept, won't be fired until the cases are sorted out, but I don't remember what the reasoning was. Because it looks really bad when your lead investigator in 2 cases is fired, because that can be used in the court of law and say to the jury, but you lost your job, right? So, but the state won't be calling him back in this case. I hope the defense will, and will hammer him.
Every day we're losing 30-day text messages. Yes, definitely.
3 inches of snow this morning. That's a lot of snow. I don't really have anything on my phone. I'll have pictures of my grandson. That's the most I have. Yeah. I'm a delivery driver. I'm back into people's driveway all the time. I find it very unlikely that she backed up at 20 miles per hour in the snow at night, drunk, and didn't hit anything but John O'Keefe. Andriel, I did a video back when the case was on, where I asked ChatGPT. So everything, of course, is because we have that key cycles. What they never told us is, did she slam? We know that she continued at that speed for 0.5 seconds after. So I put that in. How fast or how long would it take to decelerate? And she would either end up in the middle of the driveway where there was 3 cars present, or she would slam into the Jeep that no one else had testified was there until the trial started, or she would have to be a better rally driver than any Finn, because I don't know why Finnish people are great at rally, but they are, and sideswipe the car, which would have also triggered a reaction because it'll be such a violent reaction to the wheel. It's so stupid, and I hope that's one of the things that I need the defense to come out with an explanation for the key cycles with someone who is smarter than the guy that the state puts on. Yeah, but again, she's been stressed more than anyone. But I'm just glad that everyone who was at that fundraiser this weekend said that she seemed in good spirits and her family was very nice. Can't be, because it never snows in Massachusetts. I know that. Yeah, never seen someone so happy like that guy when he talked about his cannon. No, we had snow last week, and that's also too early for us. We might get week 2 in December, and then we get it back in January again. Yeah, the key cycles is one of the things they say proves she did it, but it doesn't line up if you do the math, because it never decelerates again. So either she keeps going at 24.3 miles per hour, I don't know where, until she breaks, which doesn't show up on the key cycle, which it should do, because it would be it doesn't. The math isn't mathing. That's the big problem in this case. Oh, we didn't do much. It hasn't started yet. You can stay here. That's pretty awesome. Hello, Reeby. I tried backing up in both our vehicles. I got to nearly 12 miles before I was afraid to keep going. Yeah, 24 miles per hour in reverse. You would have to be a master driver, especially there wasn't much snow. We know that from the lawn outside of the library. but it would still have been a bit wet and a bit slippery. And she's at a total standstill, slams the gas, and then accelerates and hits him, then brakes or steers around another car. You couldn't do that. You couldn't. No way in hell can you do that. And I think that some of the things that the defense could do, make it demonstrative, if Bev would allow it, of what is 24.32 miles per hour in reverse. What does it look like? Because we only saw that video that they sped up and slowed down from the state side. And that didn't really prove anything. I think that's where the key cycles came from. Yeah, Eddie should begin his opening with John O'Keefe was not hit by a vehicle. Instead of Karen Reed was framed. Yeah. Hey, Corina. Yeah, you had a lot of snow. The pictures I saw was really much. I don't celebrate Thanksgiving. The key cycle was the prosecution used lines up with where they were testing. Yeah, and that's. But they have. I don't feel the defense explained that real well. That was one of the flaws. They didn't really have an answer to it. That and again, we were watching it live, and I know me, Mike at the Jerks, Young Jerks, not the Jerks, but the Young Jerks, and Olivia, while they were doing it, was counting the key cycles and said that doesn't line up. So
Okay, perfect.
they should have done that as well. Yeah, because and again, in a big SUV, that'll him not listening to that and moving away seems so unreasonable to understand that. Yeah, it doesn't make sense. Hey, Vice's Raiders. Welcome to the hearing of the Rule 17 motion hearing in the Karen Reed case, where they are trying to get her father and mother's phone records. Oh, phone records. Hey, Medita. Snibbles. Hey, Roland. King Boob. You don't understand the key cycles other than it not really saying what they say it said it did. Well, it's because the car registers when you turn the key, and then the action that happens within. So if you hold still and speed up, it'll make a key cycle on that one, where you can see the car did this for that, and then it's a tattletale you have in your car. I don't know how to explain it, but it's just you can see the speed, you could see the axle speed on the car. That's another thing. It wasn't the road speed, it's the axle speed, because it doesn't measure road speed, because you would need a GPS to do that. It measures the axle. So again, you can't really use it for anything. Hey, Bryces, thank you so much for the raid. And you're probably going to get to bed now. Get some good sleep. And that case you're covering, yikes. Oh, not nice. Hey, before I go. Hello. Yeah, and I think that was the problem. They went with people who were a bit too smart. They should have had some people who could dumb it down, because laymen don't understand. And I think it could be a problem is if you've been on the case for so long, you have been going through all of the stuff. It's kind of like us who's been following it since last year. When we discuss this case, we'll have, oh yeah, and then there was this and there was that, and the rhinos in the bar, and someone new will say, what? The grab ass? Who's grabbing whose ass? We would know why a bot dial isn't a bot dial, and all that stuff. So I think maybe the defense got too much into it and didn't remember that they had to explain it to people who didn't know the case. Yeah, but you didn't. That's the most important thing. But I thought it was per time the car was operating. Yeah, but it's the cycle when it does something. And that's the problem, because we didn't see the following cycles.
Yeah.
And we missed all the cycles from her driving to her parents. It's every time the keys turned on, I believe. I don't know. I'm a talking head on a YouTube channel. Yep. Which could, yeah, that's the thing. It's also, if she's backing up, let's say she is backing up, and the car keeps spinning, it'll say 24 miles per hour, but she could be doing 8 if there's no, the wheels is just spinning. But they need someone to explain it to the jury. Thank you, Stephen. Hey, Diane. Yeah, I don't know if it's going to be fast or a long one today. Yes, what's his name? The guy. That was such a stupid argument. You can only fire once if you have someone in your house trying to fight you. What? Yeah, because there was 8 minutes between the shots, so that's not a self-defense. What if you lose the gun? He gets your arm, but luckily they found him not guilty. And for those who didn't watch my video, the Susan Lawrence, whatever they want to call her, down in Florida, the woman who pew-pewed her husband, not her neighbor, through the door, she got 25 years for aggravated manslaughter yesterday. So that's a good thing. She was guilty.
Quiet, please. Yay. All persons having any business before the office, heavenly county, justice in the North Park Superior Court in Fulton County. From here, your return shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
It's the same.
117, the Commonwealth versus Karen Reed. Can I come to identify themselves, please?
Thank you. Good morning, Your Honor. Hank Brennan, on behalf of the Commonwealth, along with me is Attorney Adam Lally, and also Attorney Laura Clark.
Good morning, Mr. Brennan. Good morning, Mr. Lally. Good morning, Ms. McCarthy.
Good morning, Your Honor. Elizabeth Little appearing on behalf of defendant Karen Reed.
Good morning, Ms. Little.
And good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right.
Thank you. Mr. Jackson appears with me in Zoom.
Okay, we can't see him though, Jim?
Yeah, we can't see you, is that okay?
All right, good morning, Mr. Jackson. All right, we have several motions this morning. Let's start with motion for admission pro hac vici that you filed. And Mr. Unetti, I know these are.
I will put $5 in the swear jar and say, on behalf of Vices, fuck off, Lally. Get to bed, Jeff. Have a great sleep.
Freely granted, but I have a question about here. So you say good cause exists to grant this motion because Mr. Alessi has specialized skill and knowledge in representing defendants in matters of this nature. What do you mean?
Mr. Alessi is somebody with decades of experience in the courtroom, both on an appellate level and on a trial level. He has handled many criminal cases over his career. I have actually consulted with him on a criminal matter. I know of no better trial attorney in the country than Robert Alessi. There are aspects of our defense that would greatly benefit from his expertise. I'd rather not go into the specifics in terms of the division of labor on our team, but I'd ask the court to, take judicial notice that with his background, with his experience, he is going to add value to this team and protect my client's constitutional rights.
Okay, so he's not a criminal lawyer, but he's a lawyer who does some criminal work. I just don't understand what you mean by representing defendants in
Right.
matters of this nature.
Of this criminal nature, he has represented criminal defendants throughout his career.
Okay.
Just a few questions. Who wants the text in? They don't want text in, they want the parents' phone records. It's the state. Today, it'll be about moving the trial date, Brennan's motion to obtain phone records for the Reed family and Fox 25 News, Ted Daniels' notes and on-air footage, removing impoundment of sidebar transcripts, motion to additional testing on telematics, motion opposing additional investigation of telematics due to CV's expert not knowing difference between megabits and megabytes, obtaining Morrissey's record for ex parte communications. That's on the record for today.
All right, thank you. All right, so let's go on to the discovery motions. We'll start with the requested records of Mr. Reed. I'll hear you, Mr. Brennan.
The Commonwealth has filed a Rule 17 motion to obtain phone records from William Reed for a 24-hour period. Secondly, the Commonwealth in that motion is looking for records regarding call logs for a 30-day period for William Reed. Although a different motion similarly, the Commonwealth has filed motions simply for the call log for 30 days.
I didn't. She said thank you when he said he was defense. Lefty, who else is excited to see Baker 9 weeks into this show in February? It's going to be moved to April, I think. But thank you so much, Lefty. And yeah, it's going to be fun.
For Janet Reed. The Commonwealth has a burden with two of these charges, one being second-degree murder, to show the element of knowledge. It is the government's burden to show that Miss Reed knew she struck John O'Keefe. Second-degree murder, as the court is aware, is a person committing an intentional act with a strong, plain likelihood of death. In a second-degree murder charge, there are a number of different theories that a Commonwealth can progress. It could be an intention to hit somebody, or it could be that somebody intentionally drove, struck somebody, left them behind, and didn't render aid knowing that there's a strong potential likelihood of death. When Miss Reed knew that she struck John O'Keefe is a critical issue in this case. Simply because the government has significant evidence outside of phone records to support and to convince that Miss Reed knew she hit John O'Keefe when she did. The government's entitled to.
Why didn't you use that in the first trial then? That's weird.
To the full value of their proof. The records for 30 days begin with that aspect of William Reed's records. Miss Reed calls her father and her mother a little after 1 o'clock on the night she struck and killed John O'Keefe. She calls both of them, and those calls were unanswered, according to the phone records. The inference that a 40-something-year-old woman is calling her parents at 1:30 in the morning after this tumultuous event, the inference is strong evidence that Miss Reed knew she had done something terrible. She knew she had struck John O'Keefe, and she knew.
I already hate you more than Lally. She made phone calls that wasn't answered, which means she knew she killed someone. Oh, come on now. You can't be this stupid.
Knew that she had left him behind. The 30-day period is an attempt to protect the privacy rights of William and Janet Reed by not asking for the call, the text messages, not asking for SMS messages, not looking to forensically download the phone, just the call records, because I expect it will establish that there are no other calls in that 30-day period from Miss Reed to her parents at 1:30 in the morning.
But can't you get that from Ms. Reed's phone?
No.
Of course
No.
you can.
There were 2 search warrants from Ms. Reed's phone.
I can't read them. The search warrant that was attached that I have isn't clear, so I'll need clear copies of those search warrants.
Those are provided by the defense. I can provide clear copies. The 2 search warrants from Ms. Reed's phone are from a period of January 28th, 6 p.m. to January 29th at 6 p.m.
Okay,
And the other one is January 28th, 9:30 to January 29th, 5:30.
okay.
And so they're not in Ms. Reed's records. I am not looking to see any of the other numbers that the family called, friends, family, whatever their purpose is. I'm not looking to even see it. I want to see and demonstrate there's an absence of phone calls between Ms. Reed and her parents the 30 days prior to when she drove into John O'Keefe. Now, it would help the defense. They want to expand that to 6 months or a year. I'm agreeable. Because if there was phone calls at 1:30 in the morning, I would not argue the inference that it was remarkable. That would be an unfair inference. But in the absence of any other calls, it is terribly remarkable that she is panic calling her parents at 1:30 in the morning. And here's why it's important. The type of injury John O'Keefe suffered that led to his death was a type of injury that was treatable. If he had received treatment within 1 to 2 hours, I expect that there are medical procedures that could have saved him. They could have produced a drill and drilled it into his brain to create bleeding so it wouldn't swell, or they could have cracked his cranium. Now, certainly he would have suffered significant impairment, but I expect the government is pursuing a witness, and my expectation on my research is a witness will say life-saving procedures within the first 2 hours would have saved or could have saved John O'Keefe. And so if
It is a clear fishing expedition. What he wants is to show that by calling them that night, and she didn't call them the night before or the night after or 2 nights before, she clearly showed guilt. Because you would only call your parents at 1:30 when you're sitting angry at your boyfriend's house, taking care of his kids, when you had an agreement that he would come home from a party. You can only call your parents if you hit him with a car. Then you go to bed, sleep for 3 hours to cover up your crime, and then call Jen, and take her back to the crime scene and say, there's John. Knowing now that he has passed away, you start doing CPR to cover up anything. While Jen doesn't participate in that, while Jen never ever goes waking up her sister or anything. If you didn't call your mom and dad the day before at 1:30, you killed. If Bim makes it January, I may flip out. She won't. Both sides ask for it, so I think. But thank you.
Miss Reed knew within the first 2 hours that she hit him and that medical procedures could have saved his life.
How?
Then this is relevant material to show her knowledge that something dramatic had happened. And that's
How
why I
did she
want
know?
for 30 days. Only phone calls with her mother and father. Nothing else am I interested in. The second part is the 24-hour period with William Reed. The 24-hour phone records will show Mr. Reed's phone calls throughout that evening or that morning. And it's important because Mr. Reed had an opportunity to speak publicly, and he did so on Fox 25, which is the subject of another motion. And when he speaks to Fox 25, he gives what I see as an implied admission that his daughter told him that she had hit something. I think there's more to
Yes, she hit his car backing out. That is the implied. Oh, I hate you more than Lally, and that takes a lot.
that story that will be explored at trial. The time of the phone calls to Miss Reed are important. They're reflected in her phone records in the morning that she speaks to her father while she's still in the back of a police car before she's brought to the hospital. In that discussion with Fox 25, the quote is, in your first discussions, my motion leaves off the S in discussion, but it's in the first discussions, what did she tell you? Mr. Reed asserts that she tells him about this implied confession at the hospital, which is after the actual first conversation. And so it'll be important to be able to confront Mr. Reed, if necessary, with his own phone records. He can denounce or deny his daughter's phone records. He doesn't have to accept them as true. Also, in that first 24-hour period, it is important for the government to establish that Mr. Reed and only Mr. Reed controlled the phone. In the absence of a stipulation, this is proof that may be necessary at trial if Mr. Reed takes the position that other people had access to his phone. That first conversation where she admits that she struck something, i.e. Mr. O'Keefe, is critical to the government's case. And so we cannot rely just on Ms. Reed's phone for a couple of reasons. Number one, phone records often show different communications. Sometimes calls or hangups don't register on a phone, and so they could be different. Secondly, I've learned that Ms. Reed's phone was sent to a taint team, and the Commonwealth does not and should not know what, if anything, was redacted from Ms. Reed's records. The idea of sending it to a taint team, I surmise, is that something was viewed that determined that it should go to a taint team, or perhaps the defense raised the issue. I don't have the best.
No, it's sent to a taint team because you should only have what's relevant for the case. This
benefit of the history. But what I do know is we cannot say that the records from Ms. Reed are a full accounting for her records, and so that Mr. Reed's records stand separately from Ms. Reed's records. Those are the two different types of records I am requesting from William Reed. I've been careful to make it limited. I'm not looking to see their physical phone. I'm not looking for a forensic download. After the first day of Mr. Reed's records, all I am looking for is call subscriber information and phone registers. I note the defense point of collateral information. I don't even want to see it. I just want to see if there's communication between Ms. Reed and her parents, so that if we present that inference, it is a sound inference, it is a fair inference, and it is a solid inference. And that's my argument regarding the phone records of Mr. Reed.
All right, who's arguing this for the defense?
Thank you, Your Honor.
Oh, she's good at tech stuff.
Your Honor, the defense requests that the Commonwealth's Rule 17 motion seeking Ms. Reed's father's private cell phone information be denied. The Commonwealth is seeking 3 categories of information for Mr. Reed's cell phone: his private subscriber information, all call records, call detail records, SMS, MMS, and all data use records from January 29th and January 30th, 2022. And finally, all call detail records for an entire month-long period spanning December 30th, 2021 until January 30th, 2022. Your Honor, we are 3 years into this litigation, and the Commonwealth is now seeking to invade Mr. Reed's privacy under the guise that it's seeking communications between Mr. Reed and his
She seems
daughter.
more calm.
But the Commonwealth already has a record of all of the communications between Mr. Reed and his daughter on January 29th, from not one, but 2 separate sources. The Commonwealth is in possession of Ms. Reed's cell phone. It's also in possession of Ms. Reed's Verizon records. The Commonwealth is asking this court to sanction this gross invasion of her father's privacy, so that the Commonwealth can sift through Mr. Reed's electronic data for information that is already in the possession of the Commonwealth. Now, I know Mr. Brennan says, I'm not interested in seeing anything else. But the problem is that's not what his motion says, right? He's asking for every single call, regardless of recipient, for a month-long period. William Reed has never been called by the Commonwealth to testify as a witness in this case.
So this is a new trial, right? So that doesn't
Right.
prohibit the Commonwealth from calling him.
No, Beth, but it kind of is a second trial in the same case. And stop interrupting the defense every time. You seem kind of biased.
I understand, Your Honor.
Okay.
He wasn't present at 34 Fairview. He wasn't present at CF McCarthy's, and he wasn't present at the waterfall on January 29th, 2022. And I would note that this court has repeatedly emphasized the importance of privacy concerns when it comes to an individual's cell phone. using that as a basis to deny the defendant's motions to obtain cell phone records from parties who were present that night. The Commonwealth, again, is already in possession of Ms. Reed's cell phone. That has been reviewed by both a special master as well as the court, and the court is well aware that the Commonwealth has a full copy of those communications. And what's important is that those call logs confirm that Ms. Reed did not make any calls to her father on January 29th until after she discovered Mr. O'Keefe lying incapacitated on Brian Albert's front lawn. And I've attached a copy of those records to our motion. It's quite clear. There was one call to her father on the morning of January 29th. That was at 6:32 a.m. The Commonwealth has a copy of those records. It's in their possession. And as this court knows, Lampron explicitly requires that any Rule 17 motion must be accompanied by an affidavit containing a factual showing that all four elements of Lampron were met. Here, the Commonwealth has failed to meet its burden to meet even a single prong of that four-part test. In regards to the burden that they have to establish that the records are evidentiary and relevant, the Commonwealth in its affidavit set forth no particularized facts whatsoever to suggest that relevant information will be found in Mr. Reed's Verizon records. The affidavit makes only vague reference to an interview Mr. Reed gave to Boston 25, but fails to explain why that interview suggests that relevant communications will be found on his phone records. And I would note, the Commonwealth's characterization of that interview is incorrect and incomplete. I submitted additional reporting from Boston 25, which is the news organization that published a portion of that interview. And it's quite clear that Mr. Reed goes on to state during that interview that what he's referring to when his daughter said, "I believe I hit something," was the Chevy Traverse, which the court knows. We have a video of her hitting a Chevy Traverse that morning.
Shitting a heavy Traverse.
The Commonwealth is already in possession of Ms. Reed's communications from January 29th. Those were included in the Commonwealth's motion itself. And the Commonwealth has failed to explain why it believes additional relevant communications will be found in the call detail and text records. That was not included in the affidavit. The Commonwealth states they expect to substantively admit the phone records between Ms. Reed and her father to prove that the 6:32 a.m. call took place. But they can do that with the phone records that they already have. Just because they have records from Verizon, that doesn't establish who answered the phone. That's not something that they're going to get from Verizon. The Commonwealth is well aware of that fact because they have Ms. Reed's cell phone and her Verizon records, so they can confirm that there's only one call on the morning of January 29th. The Commonwealth has provided no factual basis whatsoever to suggest that there are relevant communications that will be found on January 30th, the day after this incident. And the Commonwealth also requests that Ms. Reed's phone records for the full month preceding January 29th, 2022 is necessary to show that it would be unusual for Karen to have called her father. And the Commonwealth did a kind of funny thing, right? They suggested during their arguments that she called both parents in the middle of the night. That's not true. There was only one call to her father on January 29th, the morning of. It was at 6:32 a.m. So the frequency at which Ms. Reed called her father cell phone in the middle of the night has no relevance whatsoever. As to the second element of Lampron, here the Commonwealth's affidavit is facially deficient. It doesn't even reference this element or set forth any facts supporting that it's shown that the Commonwealth's records are not otherwise procurable reasonably in advance of trial. And the reason Mr. Brennan cannot in good faith make that statement under oath is because the Commonwealth is already in possession of these communications from two separate sources. Element 3 of Lampron was also not addressed in the Commonwealth's affidavit. It's facially deficient. The Commonwealth has failed to show that it cannot properly prepare for trial without the production of this evidence, and that the failure to obtain the evidence would unreasonably delay trial. Again, that's because the Commonwealth is already in possession of the evidence that they're requesting. Finally, the Commonwealth has also failed to show that this request is made in good faith and is not a fishing expedition. In its affidavit, the Commonwealth briefly addresses the fourth element of Lampron, but writes only, quote, The Commonwealth's motion is not a fishing expedition, as it is evidence from the defendant's phone records that phone calls between defendant and Mr. Reed were made sometime after defendant struck the victim and before the victim was found. Your Honor, that statement is provably false. Ms. Reed's phone records established conclusively that she did not call her father on January 29th until 6:32 a.m. after she found her boyfriend incapacitated on Brian Albert's front lawn. Therefore, the requested records should not be turned over to the Commonwealth. This is a broad request to review a month's worth of Mr. Reed's private cell phone information and all of his data usage information from January 29th and January 30th. This is a fishing expedition, plain and simple. The Commonwealth isn't asking for the records it already has. It doesn't need a third copy of them. What it's looking to do is sift through Mr. Reed's personal cell phone information on January 29th to see if it can find data usage information, location information, text messages with other individuals, and that is a completely inappropriate use of Rule 17. This unsupported request is overbroad and must be denied. Thank you.
All right, thank you. Did you want to respond in any way, Mr. Brennan, or move on?
Very briefly.
She's better than she was the first time around, but she still gets a little shaky when she gets nervous.
In between the multiple accusations of bad faith, what the attorney says that is most telling is they don't know who answered the phone. That's a harbinger too.
But it doesn't matter at 6:32, that's after the body is found. You want him to have answered the phone at 1 in the night, and it doesn't matter.
Trial. The prosecution doesn't know who answered the phone when Karen Reed called her parents or her mother's phone at 1:43 a.m. No, the Commonwealth doesn't. And so we have to prepare that when Mr. Reed takes the stand, we have phone records demonstrating all of his phone calls and that he had control of that phone, so there can't be a suggestion somebody else was handling the phone. Or, on the other hand, if the position is going,
How is his phone record gonna show who had his phone? Am I retarded? It wouldn't show who is. You can't. If I gave this to my neighbor right now, and you got my phone records in a month, you couldn't tell if it was me. Jesus, I miss Lally. At least he was an idiot.
to be that Janet Reed answered the phone, the father's phone, or that William Reed answered the mother's phone, then we'll call both witnesses at trial and we'll sort it out. But it is that very nature of suggesting confusion or uncertainty that the government is obligated to try to prevent at trial. And we're being diligent, we're being studious, and we're going to be prepared. And these records will help us do that. That is the exact point and reason why we need these records. Thank you.
All right, did you want to respond at all, Ms. Little?
Well, I think the Commonwealth actually brought up the issue of, it tried to basically say, I need the Verizon records because Karen's phone records don't establish that Mr. Reed answered the phone. But all I'm saying is that neither do the Verizon records. So there is no additional information the Commonwealth is going to obtain by digging through Mr. Reed's private cell phone information.
Okay. All right, so we sort of overlapped a little bit with Mrs. Reed, Janet Reed's records. Do you want to be heard further on that, Mr. Brennan?
No, I believe the court understands my argument unless the court has any questions for me.
I don't, but thank you. Ms. Little, is there anything specific to Mrs. Reed that you want to address?
Yes, Your Honor. Again, I just emphasize that the affidavit in support of the request for Ms. Reed's phone records is plainly insufficient. They haven't addressed numerous elements of land crime. That alone is a basis to deny the request, and it's not permissive. It's mandatory that the court deny the request. Land crime is very clear. If you don't meet a factual showing in the affidavit in support of your Rule 17 motion, then the motion must be denied. 3 of the elements were not even addressed in that motion. So on that basis, we request that the court deny the motion.
Okay, thank you. All right, so we will move along now. Both of those are under advisement. We'll move along now to
Bev, this is really easy. If they don't meet the requirements, then you don't have to take it on advisement. You just say, well, you clearly didn't meet the, or if you feel they met them, then you say, yes, granted. Why can't you make it? You read all of this before you came to court today. That's your job as a judge. How come we just watched a bench trial where we got a conviction and a sentencing done in an hour? Because the judge did his homework. You should be fired. You're incompetent and you're biased and you're a hack.
It's paper number 405, Commonwealth's renewed motion for all audio recordings, notes, emails, text messages, voicemails, and the possession of Gretchen Voss and or Metro Court. I do have an opposition that I received this morning and an affidavit from Robert Birch, attorney Robert Birch, who I think is present in court. So Jim, did he file an appearance too?
Yes, previously.
And we'll use that in this case as well. All right, so Ms. Little, you did not intend to argue that, right?
No, Your Honor.
Okay, so
Oh, that's
Mr.
possible.
Brennan, I'll hear you, and then Mr. Birch, I'll hear you.
The Commonwealth has filed a motion to
She's not
reconsider in
re-elected.
part, and in addition, there was a request for information that was not requested before by the Commonwealth. Your Honor made a ruling in the past to turn over portions of the materials, and in that ruling, it invited the Commonwealth after review to renew or reconsider the motion or the extent of the motion. I've had an opportunity to listen to the hearing. I've had an opportunity to review all of the pleadings relative to the Boston Magazine and Ms. Voss information. And I've had the benefit of observing numerous other statements that have been made by Ms. Reed publicly. And I've been able to contrast and compare the statements made to Ms. Voss as well as the statements made to a number of other media organizations, including Dateline 2020 and Vanity Fair. And after a review of all those materials, it is clear that there is significant materials that were not turned over to the Commonwealth that are relevant material and substantive evidence in this case. In listening to the past hearing, the position of Boston Magazine was that almost everything was entirely on record and that there were a few interchanges by the attorneys. Not only did I have an opportunity to read the Boston Magazine article and listen to the interviews, but I had them transcribed, have a copy for the court if the court pleases.
Yeah, that would be helpful.
And there were two different interviews that were turned over. One was represented at the last hearing that was 4 hours long. The Commonwealth received 3 hours and 19 minutes. It's missing, not a little bit, a significant portion of that hearing, 40 minutes. The second interview was
10% up a
represented
little bit.
in the audio recording of court that I listened to as a 2-hour interview. The Commonwealth received merely 19 minutes. So the majority of that interview was not provided. And so there wasn't just a few redactions, they were significant. In addition, which is notable, and you can glean this from the transcripts, is that there wasn't just a few interruptions. Mr. Yannetti is noted on the transcript 37 times, Attorney Little 33 times, and Attorney Jackson 33 times. And so there are significant interruptions and redactions in both recordings. These redactions in the recordings are important. One thing that stands out when you actually listen to the interviews and you look at the transcripts is that many times during the attorney's interruptions, there's a redaction, and then when the conversation resumes, there is a change, sometimes subtle, sometimes not so. There is a change in the statement by Ms. Reed. And so it is clear that there is an inference that in those redactions.
Yes, we argued this at the last trial, but he's now going to do it again. But again, this isn't the defense who's going to argue it. It's going to be the press journalist or the lawyer for NBC that's going to argue. Yeah, you ain't getting us.
Active portions, there is conversation or consultation or discussion happening that changes the direction and sometimes the content of Ms. Reed's statements. That bears directly.
She is allowed to
on the credibility of the witness. Because be mindful, all of her statements are admissible. All of them. They're all substantive evidence. There's no hearsay. There's no limitation. They are statements of the defendant. They're material and relevant, and the Commonwealth is free to use any and all of them at their discretion. And so it's not only what she says in the interview, it is what is missing in the redactions. Now, certainly there may be discussions in those redactions that involve her attorneys and Ms. Voss, but none of that is protected. None of that is protected. A defendant enjoys many privileges, but when an accused decides to cast aside their privileges, they don't get to add their own layer of protection. There's absolutely no basis in our jurisprudence for a defendant to be able to do that. They enjoy Fifth Amendment privilege as they should. A defendant is presumed innocent. But when they cast it aside, it's at their own peril. They have an attorney-client privilege. But when they obviate the attorney-client privilege by speaking in front of a third party that's not part of the prosecution team, that privilege no longer exists. It dies. And there is no reporter privilege in Massachusetts. And so what has happened in this interview is that we have 3 attorneys, a defendant, and a reporter having a free reign of interview, and then later deciding what parts of the interview they want the
I
public
heard
to hear,
that rumor
what
as
parts
well.
of the
I
interview
don't
they
know.
want the Commonwealth to have possession of. They don't have, respectfully, that choice or that power or that discretion. They can contract with each other, have their own side agreements and what they want about on and off the record, but it doesn't bind the Commonwealth. It never has, it never will. We don't agree to it. And so what we have is many instances and examples where those redacted portions are critical to understanding why the story at times changes after the redactions. And so I think of it this way. If Ms. Voss was called to testify by the Commonwealth at trial, and we have her on the stand, and I was to say to her, I've received your recordings and your redactions, and I've read your article, Ms. Voss. I want to ask you about the conversation after Ms. Reed talks about sipping drinks at the waterfall, and it's redacted. I want you to tell me what she said. There could be no objection for the defense that there's a private agreement. There could be no objection from the defense that somehow it's privileged. She would have to answer the question, this is what Karen Reed told me. So to suggest that pre-trial, somehow they can have this protection that doesn't exist in reality in the law, to protect statements that the defendant or their attorneys made that they don't want the Commonwealth to learn about, is just wishful thinking. That's all it is. And, I'm not oblivious to the fact that there are a number of statements that are made that are redacted to Ms. Voss where the defense attorneys are present in the room. There is no attorney-client privilege at that point. There's none. Arguably, all 3 of the attorneys are witnesses as well. Now, Commonwealth is not heavy-handed. The Commonwealth does not want to disrupt the defense team. The Commonwealth does not want to delay this trial. The Commonwealth does not want to put an attorney in an uncomfortable position. But they're all witnesses to a substantive statement, many of them admissions of guilt, contradictions, all of them, in the most respectful way to pursue those. The strongest way, the fairest way to pursue those with moderation is to get them from Emily Voss in the interview that exists. Now, in the pleadings, I received the response this morning. I didn't get to read the entire thing. I have no objection to it. But I did listen to the hearing. And it strikes me that the argument of the newspaper company was primarily based on 2 propositions. Number 1, Commonwealth versus Doe, promulgation. Those cases, when you read them, deal with confidential informants. Not confidential information or what someone wants to be confidential. It's not even confidential. She said it. She said it. There's a difference. And Your Honor pointed out in that hearing. Could you give me a case that talks about confidential information as it does confidential informants? And respectfully, there was no case to be produced because there is none. The cases are dissimilar because they deal with trying to get to a confidential source that may expose a source that may not be used at trial anyways because it's based on hearsay or there's no factual basis for it. This is not a confidential informant. The defense chose a strategy, a very strategic strategy, to sell their story and disseminate to the public, potential jury pool, in a way they thought best fit their needs. And they've done this continually. And although an attorney cannot produce evidence to the public or encourage it, it violates the rules of professional responsibility. They cannot have a statement that is meant to reach the potential jury. A defendant can. The Commonwealth does not resent that Ms. Reed has made statements to all of these different outlets. She's entitled to. She's presumed innocent. She can make all the statements she wants. But when she does, there is a consequence for that. And they now bear the consequence of these statements that have been made. And so, since it is not a confidential informant, it's a very public, identified person, it's Ms. Reed herself, the argument of Doe and promulgation has no merit. I know Your Honor was troubled by the affidavit of Ms. Voss and that she was afraid for her safety. And from a personal level, I empathize. In this case, firsthand, I've never seen anything like this, where witnesses have to fear walking out of their car.
Shut up with the McAlbert line about witnesses have to fear. No, they don't. They are the people attacking other people on the street. You're so full of BS, and you only been here for 2. I had hoped that you would at least try this case in a professional manner. You're worse than Lally. Absolutely. Oh, the witnesses have to fear. Turtle boy. there was no collusion. I know you want to imply that.
It's repugnant. It undermines the fabric of the judicial system. But Ms. Voss isn't alone, and I have empathy for her. Almost every witness, civilian witness of the Commonwealth, has sustained similar or far more egregious abuses. It is awful to think the level of harassment and intimidation that someone must suffer because they're simply a witness in the case. And my empathy is to Ms. Voss, but to every other witness in this case, she is in no different position. It does not impede the progress of the Commonwealth. It does not impede the fact-finding mission. It's unfair. It shouldn't happen. Something should happen as a result, but it has no bearing on the analysis in this case. It just doesn't. And so there is a ton of conversation that has been redacted arbitrarily by parties that want to use what's in their best interest, but cover up what doesn't help them. The Commonwealth is entitled to it, and we're seeking it and we want it. We want all the redactions in the first and second interview. Over 75% of the second interview is redacted. We want the notes from the third interview. Ms. Voss is a witness. She wasn't at the scene. She didn't see Ms. Reed drive into John O'Keefe and leave him in the snow, but she's a witness to substantive statements, her statements, admissions, confessions. And those notes evidence the statements of Ms. Reed. They're clearly discoverable. In the email or text message and phone call, again, statements of the defendant. Ms. Voss, reporter or not, is a witness in this case to some of the most crucial damning evidence in this case. We're entitled to it. We take no exception for it. Thank you.
All right, thank you. Mr. Birch.
Well, no charges was brought against them in
June. Metro Court and Gretchen Voss. I've been here before, Your Honor, on a remarkably similar motion. And Your Honor, at that time, made a Solomonic decision and said that 2 audio tapes minus attorney dialogue and off-the-record comments would have to be produced. And the one-on-one off-the-record interview between Gretchen Voss and Ms. Reed did not have to be produced. And the Commonwealth has simply made no persuasive showing as to why the decision should be any different now. The Commonwealth makes much of the fact that there are heavy redactions on the shorter of the 2 taped interviews. They refer to it as a 2-hour interview. Actually, it's a 1-hour interview according to the affidavit of Gretchen Voss, which had been submitted with our original opposition to the first motion. So it wasn't quite as lopsided as counsel is intimating. But in any event, the reason for the redactions is that the Commonwealth made a point in its original motion that it was not seeking anything but the defendant's statements, that it did not want colloquy of attorneys. It did not seek what the
Yes, camera is stuck.
attorneys were saying. And it said that over and over in its original motion. Now it's suddenly changing the rules and says, oops, we've decided we want those after all.
I'll just go back and see if
Somebody changed the rules and says, oops, we've decided we want those after all.
Didn't I leave that open for them, though? Didn't I leave that open for them to come back even at the first trial? To come back and request it upon review of the first?
I'm sorry, I didn't quite.
I left that open for the Commonwealth to come back the first time even, right? The first trial. And we have here now a new trial. We have different attorneys presumed with today's motion on both sides. So why are we focusing on what they requested first and what's different than now?
Well, Your Honor, I think the burden on the press is, it's still the prosecution seeking information from the press. They got a certain amount of it. They're now asking for more of it. And the question is, why do they need that more? They had made a determination at one time that in order to be fully prepared for trial, they only needed a certain amount. And they only did not need attorneys colloquy. And now they're.
It's Fox Television's attorney. This isn't the defense team arguing because they want something from the journalist. And the journalist will say, nope, we are protecting our sources.
Saying the attorney's colloquy is central to what they need. They can't have it both ways.
Okay, go ahead.
The change of subject
Yes,
from one before and after a colloquy, he says, bears on the credibility of the defendant. But if the defendant contradicts herself in the course of an interview with Gretchen Voss, I fail to see how that has the impact of serving as grist for impeachment at trial. And one has to wonder whether this motion is really an effort to keep Ms. Voss off the stand and off from reporting, because she, in fact, has suffered, as Your Honor noted at the earlier hearing, from harassment. And Your Honor noted in your order that the disclosure of the material sought would require her to divulge information that will hinder her ability as a journalist to assure sources that she will keep certain information confidential. That's what she averred. And her affidavit also details the harassment she's endured since the publication of her article, and her fear that if compelled to turn over the requested material, in particular the handwritten notes of the off-the-record interview, she'll be exposing herself to further harassment and endangering the safety of herself and her family. And Your Honor wrote, given the extraordinary public attention and scrutiny given to this case, and her fears for her own safety and that of her family are no doubt warranted. And in light of the concerns set forth in her affidavit, the court concludes that the asserted damage to the free flow of information is more than speculative or theoretical. And you said it was a close call, but given making the division, what I call the Solomonic division of providing some and limiting others, seemed to make sense. So what are they seeking now that they didn't have before? Well, in addition to seeking the redacted portions of the interviews, which Metro Corkins Council undertook time and expense to redact them to accord with what the subpoena as approved, what the subpoena as issued had asked for. They're asking now for the handwritten notes of Ms. Voss of a one-on-one off-the-record interview that she had with no attorneys present. Those are handwritten notes. There's no audio tape. They are partial notes. They are the phrases. They're not complete thoughts. They're more jog memory sorts of telegraphic mentions. So it seems likely that if required to turn over these notes, which essentially represent the work product of the journalist and her personality as expressed in her, what she takes from the interview. If forced to produce that, it's very likely the next step is that the Commonwealth is going to want to depose her or call her a trial in order to explain those notes and interpret them. And that's going to take us down yet one more rabbit hole in this case, that this already had so many. It would also have the effect, maybe the calculated effect, of preventing Ms. Voss from covering the trial, because if she is called as a witness, she is not permitted to sit in and the courtroom for the proceedings.
So she did attend the last trial, right?
She did,
On a
because she was
daily
not on the
basis?
witness list.
Right, on a daily basis?
I believe so, yes.
Okay,
Every day? Yes,
okay, thank you. And that was Ms. Voss who just responded to you?
I'm sorry,
That was Ms. Voss who just responded to you, yes, correct?
yes.
Okay, thank you.
If we're going to say Ms. Little is a bad public speaker, this guy should take the same classes. He seems even worse.
And finally, the Commonwealth asks for the first time, for texts between Ms. Reed and Ms. Voss. And we do have texts. They are, the manner in which they get forwarded from an iPhone is that they come out without the name of the speaker. You can sort of guess at the name of the speaker, but you don't see the name of the speaker. You also don't see the date and time of the communication. I'd ask that we be.
He has nothing to do with it. This is the press arguing that the press won't turn over press material.
We're willing to turn those over. They were not off the record. But I ask that we be able to turn them over in that form, which is the form we have them in, rather than go to whatever expense and trouble to replicate a different format.
Okay,
And that's all I have.
all right. Thank you very much. Mr. Brennan, I'll give you a chance to respond, but I do have a question for you based on Mr. Birch's opposition. If you've got the opposition with you, Mr. Brennan?
I have a copy of that.
Okay. So what I'm going to ask you to respond to is on page 5. First full paragraph, the paragraph begins that this litigation, but the sentence is, in other words, the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging admissions by Reed or reveals that she was not entirely forthright in her unsworn press interviews with Voss. What do you say about that? You touched upon it when you started your argument today about inconsistencies. What's your argument to that specific?
Having received this morning, having not had an opportunity to read it, could I just have one moment to read it in context?
Sure.
Thank you.
You didn't do your job again. It's amazing how everyone else can read their stuff before trial, but you can't. And again, it's just fishing.
This posits two separate ideas, the way I interpret it. The first is the Commonwealth says it needs more audio because the redacted audio provided thus far either contains no damaging omissions by Reed. The audio provided thus far contains many damaging admissions to Reed. In her first interview with Gretchen Voss, she talks about when she dropped John off and where she dropped him off. It's noticeable in many interviews, the story changes.
Can we get a camera to Lally, who didn't bring in all of these many statements that could get her convicted in the first trial?
At one point, she has them going to the side door of the house. In fact, in 3 of the interviews, he's going to the side door of the house. In a further interview, she says he went to the front door of the house. It's not subtle. There's a reason. The stories and the versions given by Ms. Reed evolve in time. Coincidentally, they evolve sometimes with the production of Discovery. And so I am not suggesting for a second.
He's sitting next to him as second chair. This guy got 75,000 to take this case. Some say it's to try and run as the next DA. I don't know. He's Whitey Bulger's defense lawyer. He didn't do a good job in that one.
That there are no damaging statements by Ms. Reed. In fact, there are confessions, there are admissions, and there are contradictions based on later statements given. And so all I can simply say is that is not the Commonwealth's position. That is stated wrongly. Also, or it reveals that she was not entirely forthright in her unsworn press interviews with Voss. Well, we're entitled to take her statements with Ms. Voss and compare them to all the other statements she made. 2020, Vanity Fair, Dateline, and others. And so the question isn't whether her statement to Voss or Ms. Voss is accurate. It is in comparison to other statements. Is it accurate? And we know that it's not. There are many instances where she is giving different statements between versions.
Also, can we talk about your witnesses? The one who had how many interviews with police and every time changed her explanation and then changed it again in court? If it's good for the goose, it's good for the baker.
So internally, in Ms. Voss's interview, as I mentioned, there are statements, redaction, a return, and a different statement. For example, she was only sipping at the waterfall, which would suggest further drinking. And then after a redaction and interruption, she's sipping water at the waterfall, as incredulous as that may be. And so clearly something happened during that redaction that changed the admission, drinking alcohol, which is part of this case, to something of water. And so I think that the claim in this motion really has no relevance to the
What if any?
It's not on point. The reason I said it was a 2-hour interview, and I'll accept that I'm wrong, is when I listened to the FTR tape, counsel respectfully said it was a 2-hour interview. And that's where I got my information from, not Ms. Voss's affidavit. So it may have been a 1-hour interview, which still leaves us with 1/3 of the interview, 2/3 redacted. That is significant. The Commonwealth comes back, we're entitled to come back when we want, if we have a good faith basis and if the court invites us. We come back now after I've had a chance to actually listen to 6 or the 4 hours of interview, or you add them up, 3 hours and 40 minutes of interview. I've studied them, I've listened to them many times. I've ordered transcripts, I've perused the transcripts, I've compared the two. I've compared them to all the other statements. So time has now made these much more relevant than they maybe initially thought. I can't speak for the Commonwealth at that point. We're entitled to the full force of our proof. We don't have to just take some. We don't have to take a fraction. Just because it's inconvenient or uncomfortable for parties, the government is entitled to the full force of their proof. In representing the people of this Commonwealth, I am pursuing the full force of our proof in every aspect because we're entitled to it. It is notable in the FTR hearing that counsel for Ms. Voss and for the publication said that the third interview they discussed, and the parties, meaning the defense attorneys, the defendant, the defense attorney, the defendant, and Ms. Voss could decide to use that material. It wasn't that it was precluded or no one could ever see it. It's only if it helped them. And so he said that they agreed that if they wanted to, they could use that material. They just decided not to. Because they decided not to use incriminating information in their story doesn't give them the power to decide who does and when they do. So we're entitled to the full force of our proof, and we're going to pursue it. We're entitled to all of these records, all this information. There is no legal argument against it.
All right, thank you. So I know Ms. Little asked if you wanted to say anything. I just give you that opportunity. Was there anything you wanted to add? Okay. All right, so that is taken under advisement. And now we have 3 more motions. I understand Mr. Albano is here, who will be filing an appearance if on all 3 or arguing all 3. But so Mr. Albano, you can come forward, sir. And Mr. Brennan, do you want to argue each one of these individually? It appears I did get an opposition this morning that goes to service, which pertains to all 3. But do you have different arguments, a little bit different on each?
I do.
Okay, so Mr. Albano, do you want to be heard after each argument, or do you want to just be heard at the end of the 3? There are 3 motions. FXT TV, Boston 25, WCVB TV, Hearst Television Incorporated and ABC, and NBC 10 Boston. Okay, thank you. And again, on these, Ms. Little, you don't expect to argue? Okay. If you do change your mind, just stand up and let me know. No, that's fine. Okay. All right, I will hear you. Why don't we start with the FXT TV, Boston 25, it's paper number 400.
As has been discussed, Fox 25 and its employees conducted an interview of William and Janet Reed. I've quoted on subsection 5 some of the language from that interview. And during my quote, it says, during your first discussion.
He
with
didn't
Karen,
know what
it should
orders
say,
he's calling
during
it.
your first discussions with Karen. There's an S left off. Nevertheless, during your first discussions with Karen, did you believe she may have hit John?
Did she believe?
Yes.
Okay, I thought you said, did you believe?
Then I misspoke. My apologies. Did she believe she may have hit John? William Reed responded, no, she felt she struck something. She said, Dad, I think I struck something. I said, what do you mean, right? This was in the hospital, right? She says, I remember, all right, backing up and hitting something. I've had the benefit of at least looking at the phone records that are available for Karen Reed and seeing there was a phone conversation that morning to William Reed's phone. That phone conversation is before Karen Reed is admitted to the hospital. And so it is by inference in the back of a police car at the scene. Now, there's some ambiguity during your first discussions. The operative word, as I see it, is first. It is a particularly remarkable statement to make that.
He has a weird mixture of a hamster and a beaver face. Stop doing this. Doesn't help you.
In the throes of realizing the great tragedy that's unfolding with John O'Keefe lying in the snow dying, that the comment of thinking that they hit, supposedly now, another car in a driveway hours earlier would be the topic of conversation at that point. There is not a fair inference that would be the subject matter. It is not a fair conclusion that a person would be so fixated on a mere nudging of another car that caused no damage hours earlier when we're dealing with the potential loss of life. And so I think it is reasonable to infer that that was actually not the complete statement. The conversation lasted on that morning for over a minute, and there was certainly conversations after. And so the defendant's father has, as he's entitled to, utilized media to try to sell a story to help his daughter. And during that airing, it is clear and obvious that not the entire conversation with William Reed has been provided. During these stories, oftentimes there is summaries to progress the episode much quicker. And so all of his statements, which may not be a lot, but all the statements to that employee of Fox 25 who did the interview should be discoverable so that this statement can be put into context, similar to the doctrine of completeness. We should know what the entirety of the conversation interview was so that we can assess this statement and draw the proper inferences from it. It is expected that William Reed very likely will be a witness at trial. He will be asked about this conversation. He may be asked about what else he had said. It will be impossible at trial then to try to produce the other statements that he has made to this network or this employee. And so the Commonwealth or anybody who would be questioning him would be just simply left to the whim of his answer. And I'm not satisfied to do that. I do not think there is any protection. He is not a defendant. There is no privilege. And so there is no reason to protect this information so that it can fairly be brought into context so that when he is cross-examined, if there is evidence of impeachment or cooperation, that both sides are aware and know of the substance of that material. And that is the reason.
Because her dad said that she hit something. And because she must have said it at the time she was in the cop car in the morning where John was dying outside, which he wasn't because he had already been removed and driven by the ambulance. She couldn't talk about hitting John's car. She must have inferentially talked about this is.
We request the pleading in number 400 for the Fox 25 footage that was not aired.
Okay. Have you had a chance to read Mr. Albano's opposition this morning? It's not very long.
I haven't, but I can say Mr. Albano kindly called me. He outlined the issues in an email. He made this a much more streamlined and agreeable process. And so I credit him with his effort. I don't need to read his response. I'll appreciate what he says.
Okay.
My short interaction with him, his total candor, I have no hesitation what he says in his representations. I might disagree, but I don't need to read his pleading.
Okay.
There are two, NBC and ABC. If Your Honor would allow me to start with NBC, because I think we can
Sure.
streamline that. NBC 10 has agreed to give promo materials in their possession. I've not only spoken to Mr. Albano, but I've spoke to the attorney for the subsidiaries that we also had subpoenaed. And they told me that as subsidiaries, they do not have.
And no, it's not hearsay because it's a party opponent they're talking about. If they were talking about what Jen McCabe had told Karen Reed's dad, then it would be hearsay. But because she is the accused, you can tell others what you can talk about what she told others.
Possession of the materials of the parent company. And I received letters from the attorneys stating as much. So as it pertains to NBC 10.
Yeah,
the,
and you can
position
trust
is
her when
that
she says something, and you can't trust her when
one
you
of the
say something
subsidiaries
else.
is going to send us
It's just stupid.
promotional materials. And as far as service on the parent company, I don't think the Commonwealth succeeded, despite the fact that we made numerous efforts in hand mail UPS to a number of subsidiaries. I don't think we satisfied, so I do not want to ask the court to progress that.
Okay. Do you have a timeline on when you'll get this material?
The promotional materials?
Yes.
They said they were putting them together. I did not ask for a timeline.
Okay.
The promotional materials are a very small fragment. It's, I've only seen one clip aired. I don't know what else they have, but it should not take them long.
Okay. I don't have a paper number. Jim, do you have the paper number on NBC 10? Here, just, you know what, Jim, you can give it to me after. I don't have that paper number or the other one. All right, so do you want to?
427, Your Honor.
What is 427? All right, so do you want to move on to CVB TV?
Yes.
Okay.
WCDB TV has been served, and they've notified that they're not in possession of the materials, have no control over the parent company, and they are not part of the company. And so I no longer am asking WCDB TV to produce these materials. Instead, in the alternative, we have subpoenaed the registered agent in Massachusetts, the registered agent for the parent company. They have been properly served. If we look at the Secretary of Commonwealth of Massachusetts Business Entity Summary website, not only do they have a principal place of business in New York, but they also have, as a registered agent, a local address, 84 State Street. So our position relative to the ABC materials is that ABC has been properly served locally. Unlike NBC, that did not have a local registered agent that we could find, or perhaps does not have one, ABC does. ABC does business in Massachusetts. In fact, these interviews with Ms. Reed may have taken place in Massachusetts. I don't know. But they have.
Then you can't
roots in
use it.
Massachusetts in that they
You're
do
not in
business
church,
there.
you're in
They have a
court.
local registered agent. And the
You don't
reason to have a registered
think,
agent is
you
to
don't,
accept service, provide notice, in cases of objections, and to provide materials.
you
It is
don't
done
believe,
routinely in
no.
civil cases when a registered agent is
Jamie,
notified. They are then obligated to get materials even if the REM exists in a different place. Their position is that the REM exists in New York. That is irrelevant to the assessment in this case. To suggest that somehow the physical property being another jurisdiction is not in the control or purview of the local registered agent would just be enacting a shell game where local or companies could pick jurisdictions they find most favorable, do business in outside jurisdictions, and avoid the consequences of that. That I don't believe is how the law is set up. As a registered agent, they are the same as the company. They just have a local contact to accept all types of service, communications, and responsibility. And so our position on ABC as far as service is concerned is they've been served through the.
It must be a verdict
And
because
therefore,
they
whatever
were on verdict
materials
watch
exist,
earlier. I believe.
regardless if they're in Massachusetts or in New York, they are required to obtain them and they're required to produce them.
Okay, so Mr. Albano disagrees with you, and on the third page of his memo under paragraph 5, so I will give you the opportunity
Agreed.
to read that.
Okay.
Under that fifth paragraph. Do you want to address the substance of your motion regarding ABC?
I do. Much like other recorded statements, we see from the Nightline in the 2020 interviews, there are a number of public statements that Ms. Reed has made to a national audience that don't reconcile with other statements she has made at other times. I've given you the example of not knowing which door she supposedly saw John Keefe go into. There is differences in her stories and versions about where she was that night after she left the O'Keefe house. There is a number of examples where the different versions given contradict each other. And so although they're all substantive statements, they're all admissions and confessions, they still have a value in the fact that they contradict each other. And so the episode that is aired, 2020 Nightline, you hear
I don't give two
oftentimes
cents about the
the
YSL
author of the
case, though.
story.
I don't care.
Not even the interview, the author.
I don't
saying,
want it.
And we spoke to the person.
If
and then
anyone
this is
else
what
wants it,
happened,
they
and then
can
go
ask
to
for
a
it.
clip of an actual interview.
I don't give
The
2 cents
summary
about
by
it.
the author is not admissible. It can't
Come
be
on.
used substantively. It can't be used to impeach Ms. Reed should she testify. It is hearsay. It's inadmissible. And so these summaries have a genesis somewhere. There's a reason why the reporter is asking certain questions, or more importantly, the author is summarizing testimony, oftentimes inconsistent with other versions. And so that means that there is footage from which the author has gleaned this information. There's either footage or there's a conversation with Ms. Reed. And so those are statements, not similar to or dissimilar to Ms. Voss interviewing here. Those are statements of a defendant, which are substantive evidence for their full value. And so that footage we're entitled to see. There's nothing that should protect it. We should have the opportunity to review all of the statements and also put the ones in context that were broadcast to the nation. And that's the substance of why we want it. I'll have to take a moment to look
Sure.
at the response.
Okay. Mr. Albano, we'll give him a couple of minutes just to read it. Sure. Jim, does this have a docket number yet?
This is worse than I thought it would be.
Paragraph 5, it's on page 3. The pages aren't numbered.
He has nothing.
Actually, you should start at 4. Or why don't you read the whole thing?
He's just
I'd like to
rehashing
have a
what
seat and
Lally
read it.
did. And again, that she can't remember. We all seen the house. I asked when we saw that house if anyone ever used the front door, because it would be unnatural to me to go from the driveway to the front door. I would always be using the side door because that's right next to the driveway. The front door would be the nice entrance that you use when you have a Christmas party or something. The rest of the year, you would just walk in through the kitchen to leave your dirty shoes there. So her saying, I dropped him off and he went to the front door. It doesn't mean anything. It's it's one of those verbal things that they put way too much inference in. It's so ridiculous. And again, his witnesses has changed their story so many times. His witnesses has deleted phone calls. His witnesses can't even tell you where they gave their dog to. They met some woman from Vermont halfway there, because that's how you give your dog away. It's so ridiculous that he's arguing that she must be guilty because she called her dad or didn't call her dad. Or
Thank you. Your Honor, our position is we disagree with that proposition. We are not trying to subpoena another state witness. We're trying to subpoena materials from a company, and although the company has a principal place of business in another state, by having a registered agent, we believe that gives us jurisdiction. I can understand the company would like to remove this to New York. There is a reporter's privilege in New York that is profound. It is not so in Massachusetts. In Massachusetts, there is none. And so I see why it is the company's preference for us to go to New York, to use New York law, but I don't believe that's the case. I believe as a registered agent that we have an entitlement to subpoena them here, and we follow Massachusetts law. There are a couple of cases in the memorandum that I'm not aware of. I think it would be prudent for me to research and jeopardize, and because I think I have an obligation to do that. I would ask you to allow me to have a day to provide a brief supplement. It's not to re-argue the case or the merits of the case, but if there is adverse case law, I want to recognize and acknowledge it. But not.
I'll give you that opportunity, but I will hear from Mr. Albano today since he's here.
Of course. But our position is, although they would like us to go to New York, we can subpoena in Massachusetts to the registered agent, and that entitles us to the material. So that's the way we've done it.
Okay.
Thank you.
All right, Mr. Albano.
Thank you, Your Honor. The two cases I cited, just to be clear, they address the Uniform Act, which Your Honor dealt with last year. They don't address the specific issue the Commonwealth has raised, which is, okay, you have a registered agent, we serve the registered agent, does that trump the Uniform Act? I have to say, I did not find a case that dealt directly or even indirectly with that. But here's why I believe the service issue does not override the Uniform Act. First of all, we're dealing with a statute. Statute talks about a witness in another state. There's no dispute that ABC is a foreign corporation with a principal place of business in New York. Now, the analogous areas I thought of was, okay, let's say someone wanted to sue ABC in this court. Yes, they could serve them.
come on. Hello.
They could.
What happened? What? So the feed died. Frozen, 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 frozen. Well, that's always nice. This isn't my internet feed. This is Massachusetts. Who lived in Massachusetts?
Case, and that just generally explains how this Uniform Act works. You go to the Superior Court here, you get an order, you travel to New York, and New York decides whether the subpoena will issue. The second case, which I think was in re contempt or something like that, was the SJC saying, by the way, the receiving court, and in that case, Massachusetts was the receiving court, we don't just rubber stamp these if there's a privilege issue in our state. And so that's what tells us that if this court issues an order under the Uniform Act, Commonwealth travels to New York, the New York court then decides, does it enforce it, or does the privilege that exists in New York, is that privilege dispositive? And that's what we say is the right answer here, that, yeah, they have a point, they can make service, but it doesn't override the statutory requirements of the Uniform Act. And as to the other, I think things are pretty much under control with the other motions. WBTS, which is NBC 10, has previously published those promotion ads for the show, and they say, well, no, they've already been out, fine, we'll get you copies, and that's what I've been told by the client as well. WFXT, which unlike ABC is here,
Right.
Does have some raw footage. The station's position is that if Your Honor decides under the Rule 17 standard that yes, this footage is relevant enough to come within the Rule 17 scope, then WFXT will produce that information. I do expect it will already be published before, so the unpublished I do expect won't be unpublished anymore, so they'll probably be in a position where they're simply turning over published information,
Okay.
not unpublished information. But I do think that, so I think WBTS and WFXT are effectively.
You're right, as always, Zach.
Okay.
Nobody super chats.
Do you want to respond, Mr. Rand? Thank you, Mr. Albino.
I'd just like to give one example that I'm sure you've thought of, and we see it often in tort law. If U-Haul is a foreign company, I don't know where it's located, but if the principal place of business is in Texas, and there's an accident here in Massachusetts, and I'm requesting as part of my litigation corporate materials, I do not have to follow
Everything's
the
the same.
Uniform Act to go to Texas or litigate in Texas under Texas law, because the company operates
Kim
also
Fair.
in Massachusetts, as does ABC.
That's not fair. You need at least 4 filters on her when she looks nothing like her pictures. Come on now. She's normally with all the Instagram filters on.
I can sue in Massachusetts, and that company, this registered agent, is obligated to get those materials for me. Otherwise, a company could simply hide in whatever state is most beneficial to them, make it impossible to litigate or obtain materials, and there would be subterfuge throughout the entire process. We have jurisdiction here because they operate here, because they have a registered agent here. It does not matter where their corporate or their headquarters is. Thank you.
All right, any follow-up, Mr. Albino? Sure.
My first point is that we're dealing with a statute here, and the statute says this is how it works when you have an out-of-state witness in a criminal case. So that's different than civil discovery. The second thing I'd say is ABC has a registered agent here, but WCVB is owned and operated by Hearst Corporation. Hearst Corporation is totally separate from ABC. That's why neither of them could produce the documents in this case. So I just want to be clear that the presence of an ABC affiliate here, owned by an entirely separate company, Hearst, does not mean that ABC is here in Massachusetts. They're a foreign company that has an agent for service process. They don't have offices and the like here in Massachusetts. Are they doing business here in the sense of transmitting ABC News programs through affiliates? I don't argue that. What I'm arguing is there's not the service, the fact that they're subject to service does not override the requirements of the statute.
Is there a distinction between obtaining records and obtaining a person's presence to testify?
The SJC has said in the grand jury case, the first case I cited, that the same procedures apply for documents as for witnesses.
Okay.
Thank you.
All right, thank you. So those are all the Rule 17 motions we have. Am I missing anything? Those are all the Rule 17 motions.
Everything the Commonwealth has proposed. Thank you.
All right, so we have some housekeeping matters that I just wanted to check on. I still have the motion to continue under advisement. I need to see how we progress with it. The Commonwealth's notice regarding the testing of the telematics system, where do we stand with that? Mr. Brennan? I know you had said you told them that, you know, Thanksgiving rather than Christmas to highlight big holidays, but where are we?
I did, and if I could have had it done quicker, I would have got somebody else. I have spoken to my expert numerous times. He has coordinated with the defense expert. They are heading to Texas on December 2nd.
Okay.
On December 2nd, they are going to test all of the chips, and there's an SD card that we expect has information on it. And then they're both scheduled to travel back to Massachusetts for December 5th.
Okay.
And they're going to do what's called a chip on, where they take the chips, the SD card, they reapply it to the boards, they put it back in the modules, and they put it in the actual car because there's different software which will give it even a more fulsome reading. And so after the December 5th event is done, I've asked my expert if I could have all results within a week. I have an uncertain response, promise to do his best, which really doesn't give a lot of meaning, but my hope is within 7 to 10 days.
Okay, thank you. And I don't know, Ms. Little or Mr. Jackson, if you have the answer to this. The transcripts of the sidebar conferences. Ms. Little, do you have any scheduling idea on when those will be available?
Yes, Your Honor, I do believe that Mr. Jackson had spoken with the court reporter and emailed the clerk's office with an update. It's going to be a little bit longer than initially expected. One of the reporters had to have like a family emergency and needed some additional time. And so I believe, and I'll have Mr. Jackson correct me if I'm wrong, but I believe she needed until about 6 weeks to get the sidebar conference.
6 weeks from the November 13th date?
6 weeks from about a week after the November 13th date. Thank you, Your Honor.
Thank you. All right. Mr. Jackson, did you want to speak?
Your Honor, Ms. Little addressed the court's specific questions about the transcripts, and that's as accurate as a bit of information as I have, so I'll submit on that.
All right, thank you. All right, that is it for today. The Commonwealth is going to file a response to the discovery of communications in possession, custody, and control of the Commonwealth by 11/27, right?
Yeah, you missed her.
Yes. Your Honor, I provided the defense this morning with a response to their motion. We'll
Okay.
file it with the court. It is a request that they made that is very labor and time consuming, but a very important task that I've been involved with. I've expended many, many hours, and I need many more. We do have, or I have produced, or I have a production that I'd like to produce to the defense. I've shown them a protective order this morning to see if they were agreeable. I do not want to speak for them. If there is a protective order, I can turn over the first production that I produced, and there is more to come.
All right, any objection to the protective order? I have not seen this document, obviously, nor the proposed order.
Right, there are a couple of issues related to this motion in addition to the protective order that I'd like to address with the court that I've briefly discussed with Mr. Brennan.
All right, I haven't read this yet, so I won't know what you're talking about, Mr. Brennan.
So I believe you have read our motion, right? The motion that
I read your motion, I haven't.
Right, so it's just in relation to the motion, Judge.
All right.
So,
She really doesn't like Giannetti.
Your Honor, generally speaking, we do not have an objection to a protective order as long as it is issued without prejudice, which I believe Mr. Brennan is in agreement with.
All right, is there one here? Was there a proposed protective order?
I have it right here, Your Honor. Mr. Brennan printed this to us this morning.
Yeah.
He's free on my channel.
So I have not reviewed that, Your Honor, but I'm asking that the contents be allowed to be shared with the entire defense team, including our attorneys, our interns, and our client. I don't believe Mr. Brennan has an objection to that, but that would be our request with regard to the protective order, with the understanding that we could come back before the court and revisit that if we deem it appropriate.
Is there any objection to the sharing with?
There's no objection to the parties that would like to share it with, and I understand it's without prejudice.
Okay.
Yes, and with regard to the motion itself, Your Honor, I had come prepared with an argument for the allowance of the motion. Given Mr. Brennan's, the work that he's done in terms of trying to gather this material and get it to us along with the protective order, I assume that there's no general objection to the motion, so I don't need to be heard in that regard, assuming the court would allow the motion.
She seems to like Ms. Little the most.
Raise an issue for the court, actually two issues. One is that we were informed this morning that Mr. Brennan has gone through Mr. Morrissey's cell phone. Apparently there is one work cell phone and one personal cell phone. Obviously the personal cell phone becomes relevant because he used the personal email address to make an ex parte communication with the court. One concern that we have is that we were told this morning
But this is
that
Turtle
with
Boy.
regard to Mr. Morrissey's text messages, not emails, but
This
text
is
messages,
Declara.
apparently they're somehow remarkably set to auto delete after 30 days.
Well, it is all over the place. It's because it's multiple motions. We started out with the Rule 17 motions to get the dad and the mom's phone records. Then we had the motions to get evidence from the TV stations. Now we're talking about then we had the car and yeah. Now I'm a bit lost.
That obviously raises some questions for us, maybe the subject of a future motion. But more immediately, the concern is every day that passes,
Yes.
we're losing text messages from 30 days prior. So, through today, I
Can they
believe.
be preserved, Mr. Brennan?
I've been preserving them since I started the task last week. I'll continue to preserve them.
All right, so that,
Yes, that deals with that issue. So the only remaining issue, Your Honor, is with regard to the searches that Mr. Brennan conducted himself. He had searched for all emails sent from Michael Morrissey's iCloud personal email to any emails that had a JUD in the suffix of the email address.
okay. The significance of that is,
The significance is that would supposedly capture any ex parte communications with members
Why? Back up to what?
of the judiciary or the clerk's office, and I appreciate that effort. However, we assert that it's insufficient. We believe that searches should be done of his iCloud email for the name Reed, spelled
Sorry, I didn't see it.
R-E-A-D correctly, or Reed, R-E-E-D, which is how Mr. Morrissey typed it in his ex parte communication with the court. We don't know if he did that for the purpose of avoiding a FOIA request or if he just misspelled my client's name. But we believe there should be a search for both of those spellings. And in addition, we also believe there should be a search of his email address, the personal email address, for the names of the relevant witnesses, and we can give the court a list, for the names of all judges who have sat on this case, in terms of, is there an attempt to communicate with a judge on some type of personal email account, like he used a personal email account. And then also we believe there should be a search for any clerk's office employees for the same reason, both at Stoughton District Court where this case originated and this court as well. We have obviously reason not to trust Mr. Morrissey in light of his actions using this personal email account to make an ex parte communication. And we'd ask that a more thorough search be done for these types of communications.
all right, so why don't you continue to talk with Mr.
It's his personal. They want it from both, from all his personal accounts. So because it's the outlier from the Turtle Boy case where they say Morrissey used his private ways of communication to communicate with people at the courthouse expressing anger that Turtle Boy didn't get hit with the gag orders and the ROs.
Brennan, and we can have a hearing on this motion if there's anything that you still need on December 12th when we're back here for the Dover hearing.
That's fair enough. Thank you, Your
Does
Honor.
that make sense, Mr. Brennan?
It does. I've taken extensive steps to do this myself to accommodate the defense in the most broadest fashion. And I'm going to do that. If they want to discuss how I can accommodate them, I'll do my best.
All right. So we will see everyone December 12th. So when do you expect to get me any written material you want me to have prior to the Dover hearing?
Yeah.
Yes.
Your Honor, we draft the landing and hearing motion. I need to review it. I'd like to get it to you by the end of the week.
That's great. I expect to be here at the end of the week, so that's great.
Thank you.
And your response by next week, Ms. Giannetti? Ms. Little?
Yes, if we could have it at least a week, Your Honor.
Okay, so I'll give you 10 days,
Thank you.
as long as that gets me before the 12th.
No problem.
All right.
Yes, Your Honor.
Yeah, if I can get it, as soon as you can get it. All right. Anything
May I-
else? Yes.
I'm sorry to interrupt.
That's okay.
May I inquire if the protective order is going to be signed by the defense?
Are you going to sign the protective order, Ms. Giannetti?
I expect I will, without prejudice.
I have the materials. I'll just wait.
Okay. All right, so if you sign it, then I'll endorse it, Ms. Giannetti. You had it, right?
Yeah.
Ms. Little gave it to us just
I
now?
believe we just gave our copy to the court.
Yes.
All right, so this is the one that needs to be signed, and I'll endorse it. Do you want to take a look at it?
Yes.
Yeah, but you should also then produce your phone if you become a witness. And again, there's a problem in this one. He's a DA, and if he's using his private phone to skirt the FOIA rules, he should be fired on the spot because that's illegal. The FOIA rules is there to protect the civilian society against overreach by prosecutors. So if he takes his phone and writes a judge, you better fix this because I want this or that, and pressures a judge and uses the private phone to do official business so no one can do a FOIA request, he should be fired on the spot and prosecuted because that's obstruction of justice if he uses his private communications to get away from FOIA requests. I don't know what the protective order is for. I didn't hear it.
Mr. Brennan, I know you have an electronic signature. I'd like you to sign this as well since you're here.
Oh,
Yes, Your Honor.
thank you, Dennis.
Sign that and
But
I
no one will leak it.
endorse it.
We actually have that rule, and our prime minister, during the Chinese cough, set her phone to auto delete and said, "Nope, no one can get it." And Apple said, "You sure you can?"
No, thank you, Your Honor.
All right, thank
Can't
you, and I
find them.
appreciate counsel and the third-party record holders coming in today.
12:12, 9 a.m. All rise for the court, please.
It's 12:12. 12:12, 9 a.m. will be the next part of this. This is a farce now. It's ridiculous how much money we are spending on what today turned out to be a massive fishing expedition. They have nothing. They are going to do the same thing they did in the first trial. They are going to imply that by doing something, it means you actually admit that you're guilty, which it doesn't. We heard today that calling your dad without him picking up is admission of guilt. calling your dad and him picking up is admission of guilt. Saying the front door, which could technically be the side door, is an admission of guilt. Talking to a journalist and saying, instead of sipping, saying sipping water is an admission of guilt. Dear people of Massachusetts, you're paying $75,000 plus whatever else this guy is going to cost you, because I don't think $75,000 is enough to pay for this horrendous special prosecutor. I'm just saying, 75,000. They're going to be very selective with the jury. Well, they should always. Yeah, no rulings so far, and it's almost a month since we had the last hearing. It's horrendous. But if you don't call your dad, it's an admission of guilt. Very sucked, yeah. No, and that's the crux of the case. Physics doesn't lie, and it doesn't matter how much of a B word Karen Reed was in Aruba. It doesn't matter if she was yelling on his phone. It doesn't matter that the text messages that they showed, they probably wasn't the happiest couple in the world. It doesn't matter, because the doctor said, and even the death doctor from the state said, it's not consistent with car strikes I've seen. So it doesn't matter how much or how little they loved each other. It doesn't matter how much or how little she was drinking. Well, beyond never drink and drive. It doesn't matter if she called her dad or didn't call her dad. It doesn't matter even how much snow there might have been at that time. What matters in this case is John O'Keefe was not hit by a car. Karen Reed's SUV hadn't hit a person. That's all that matters in this case. But sadly, this case will be about calling her dad to the stand saying, were you with your phone at that time? Yes. Did you pick it up? Yes. What did you talk about? That John had died. Did she say she was guilty? No. But you said this in an interview. I wasn't under oath. I was just saying stuff. Or, yeah, that was what I believed at the time. This is going to be another lallyism. It's the lallygagging all over. We're going to spend 8 weeks hearing the state present a case with no facts. All we're going to hear is who was at whose house after the incident, who were not registered at the crime scene at the time of the search team cleaning the cars, the crime scene. Who, if any, drove by 8 years later and found 2 taillights and a number plate saying Karen Reed did it. This is redunculous. This is an injustice, and I don't give 2 craps about what the state, they don't have a case, and it's getting more and more ridiculous that we are wasting taxpayer money. And I don't care, because I don't pay tax in Massachusetts, but as a crime watch lay tuber, whatever it is, this is ridiculous. We wasted. I'm glad Alan Jackson didn't take the red eye in, because imagine flying in for this just to hear him say everything is an admission of guilt, calling your lawyer is an admission of guilt, taking your shoes on one at a time is an admission of guilt. It's just, it's stupid. Yeah, that's, Please invest in dash cams. It can't be used in court, I believe. It's the Seinfeld prosecution, a prosecution about nothing. Exactly. Yeah, it's political. All of it is just talk, and no evidence. And when the evidence comes up, they say, well, Newton didn't really figure out gravity. Well, you can have, but at least you need something else than she was mad at him and yelled at him at the phone. Everyone was testifying that that night at the bars, they were very, very lovey-dovey. Actually, so lovey-dovey that the Indian guy got in trouble. No, the Portuguese guy got in trouble with his wife because he wasn't as lovey-dovey as they were. And they want you to believe on that 7-8 minute car ride, she went from I'm lovey-dovey, everyone is fine, everyone is smiling, no one saw her inebriated in any significant way, driving from the bar to Fairview 34. She totally blasted her mind because of some chick that he might have hooked up with, and then decided when she got there, I'm going to pull up 60 feet and then I'm going to slam it in reverse, hit him. Maybe if the defense just told that story instead of going too far into everything else, because this isn't about who else did it. This is about who didn't do it. And I think we kind of get lost sometimes in this case that everyone wants to pick and say Colin Albert, Chloe, Brian Higgins. That's not important. The important thing is she didn't do it. And that's for the defense to prove. But they claim in 10 minutes, she turned from, I love you, to, I'm going to kill you. Without any explanation other than, because trust me, bro. And she did something in a car that I couldn't do, that most of you couldn't do. And no one heard a big, I don't know if it's a V6 or V8 engine, even though Jen McCabe testified that she was looking out the window almost constantly. She was even looking out the window, seeing Karen Reed's car 15 minutes after it left. That doesn't mean anything. She's totally trustworthy, but Karen Reed saying side door, front door, side door is an admission of guilt. Let's go back and look at Jen McCabe's admissions of guilt then, if every lie is an admission of guilt. All of a sudden, Higgins' car is in the middle of the road. No one in any testimony in over a year have ever put a Jeep at the mailbox. No one. So if a lie is an admission of guilt, how many more people are guilty in this case? Greek, it's the same thing. You can't do that. You'll have a jury. Don't make up all of these. People are placed on the jury and all of that. And it's the same as claiming that the FBI will fix it tomorrow. There's no such deals that can be made with the jury. It's a random process, and the jury or the defense will help pick him. So it's just as ridiculous to say that as saying, as some people do, the feds will come and save her tomorrow, because that won't happen either. Women can be pretty explosive, especially when Mexican food is involved. Yeah, and she has some tummy problems. Well, I don't know if I can analyze things. I'm trying to use common sense. It can be done with the proper gearing and a wheelman. Yep, but you're not going to do it with a young, well, compared to me, a woman who isn't a skilled driver is not going to do it. Hoslong is admissions of guilt, but butt dials is not an admission of guilt. Yeah, the snow that wasn't there. And why did you plow the driveway up? I like to do it as a joke. You would ruin his driveway if you plowed with no snow on it. Again, I don't know who were on the jury, or maybe they just didn't understand. And again, we have to have to put the blame on the defense, for it's the defense who didn't make the jury understand it, even though I thought they did a pretty good job, except the telephone data. I didn't understand a word of that. But you should have pointed out that, say, but there was no snow. This is the library video. You drove past this place. You're claiming there was snow in the driveway just to show how much they lied. Oh. Yeah, find out what case it is so we can cover it. Butt dials are admission of guilt. No, it's not. Because you can have 7 of them and turn them off before it hits speaker and or voicemail, and it's not a problem. Well, you can't do any deals with the jury. The jury is the ones you have to do the deal with. They are the one who's finding out who's guilty or not. I still, after seeing him twice, I think he's a paid idiot for hire. He'll do whatever they pay him for. But what I'm thinking is, at some point they have to drop at least the murder charge. They have nothing, and they won't get anything. Get her for manslaughter, try to do that. Manslaughter under the influence, try that one. But murder, you have no way of proving that she decided to do it or should have known. There's no way. I don't understand why they keep going. I said this the last time I've had Better Row on. I still believe that at some point at Friday night, they're going to drop an email saying, well, we have decided not to charge it. That's still, and don't take it anywhere and say it anywhere, because I have no proof of it. That's just would be the reasonable thing to do in my world. But again, it's the Commonwealth, and something the Commonwealth doesn't have is common sense. Bada boom. I'll be here all week. I have my personal AI do all my PR work. I should do that. Should do a gift exchange in Discord. People should give me gifts. Just proves that Jen McCabe's ass cheeks has her fingerprints on it, specifically at the point of the iPhone's biometric button. Yeah, and that's, again, you want me to believe that you were having smacks with your wife while butt dialing your body for 22 seconds, where you can say you can't say anything in 22 seconds, because that's what, if anything, can be said in 22 seconds. I think 22 seconds is a pretty long time. I could have said a lot of words in 22 seconds. But not according to Mr. Ass Grabbery himself. You want to tell me that you didn't take your service card because you were drunk, and then while you were still drunk, you went back to work and started moving cars around at 1 a.m? Because that's totally a thing you would do. Again, this case is so effed up. It should have been dropped. It won't be dropped because it's become personal in some way because of the McAlberts. I don't know. I think watching this today, it just further enforces my belief that they don't have anything to use in court. They have nothing. Their case is too weak. I really don't know what to say. It's an S show. It's a fishing expedition, and they don't have anything to go by. This is 2 years after they started pursuing this. This is after we had 9 weeks of trial. We are back at the well trying to find some incriminating evidence that we can say, well, if you close one eye and turn it upside down and maybe tilt your head, it could look like something. Because her dad answering a phone, and we have to figure out if it's her dad. Did she say it in this conversation or in that conversation? I'm sorry, it's just too stupid. It's so stupid. This is where we are 2 years into a trial. Going back to test the car's telemetrics because you had an idiot do it the first time. Yeah, Crispy, it's and then again, you're paying 75,000 to have a new guy lie about it. You could have Lally say, "What if anything?" 1,000 times for 75,000. He's getting paid anyway. Yeah, that's the problem. That's the big problem in this case. Rational, reasonable, and logic thoughts are not allowed. No, and physics either. It's so stupid. Yep. If we get Morrissey's records, yeah, that's going to be really interesting. There's probably a bigger chance that Aiden will get them than Cam Reed will get them. But once he has them, they're out there. And they will leak as a sieve. Well, it's a crap fest, but yeah. It was just that she didn't understand why Yannetti wrote the way he wrote, why what he was there for. I think he was granted pro hoc, but it was just that that he had stated that he had done this before, and she couldn't understand. Did that mean he had done it before or hadn't done it before? Doesn't matter who prosecutes, everything comes from the DA. Yeah, and that DA is tainted, and I really hope that Aiden gets his, because I don't think Bev will ever get them in her case, but I hope an honest judge is on Turtle Boy's case. So yeah. Well, she can't because I don't know. I'm just gonna imply a lot of stuff that I have no basis. I'm gonna be Baker of the Gulf. She needs someone to counsel her, and she's probably, the way I see it, she talks with someone who's probably closer to the state than the defense when she does these rulings. I have a hard time seeing her making her rulings on her own. And sadly, I think she has shown her bias, and that's when she makes her rulings, you can see that bias. So yeah. Yeah, and it was maybe, I don't know if it was worded the wrong way, but I think with her, you better spell it on an Etch-a-Sketch. Yeah, he's worse than Lally. I find him worse than Lally. Yeah, again, but I think I don't. That's why when I go to the US the next time, I won't be going to Massachusetts, because I'll probably be put in prison for something I never did. So yeah. Well, we have those phone records because actually you can use Cellbrite to figure out who called who, and that's the 22 seconds where they couldn't have talked about anything because one of them was sleeping and the other one was mixing his wife. I don't give 2 cents for that. It's not worth anything. So if I was Lally, I would be happy it wasn't my face getting blown all over again, I'm the small one. I had 180 people watching. I bet you if you go to the other channels who covers it, there's probably 50 to 100,000 people watching right now. I would be happy it wasn't me being yelled at by Emily D. Baker for being a cutwaddle, whatever that is. And talking about cutwaddles, I think I will go make myself some dinner, and then I'll do a show tonight at 11 p.m. Eastern Standard Time, as we do 3 times a week. Hopefully you will be there to get in bed with me, or get out of bed if you're in Europe, or maybe get home from work if you're in Aussie land. Thank you for being there for 4 months. And we're happy to have you as well. Well, he has to pay extra at the madam. But no, I'll be doing my night show. For those of you who want to see the Laurie Shaver, she is, I believe it's today, she's getting her sentencing. Brandy will be covering that one. I believe it starts at 1 Eastern. I'm not sure, but I believe Brandy is covering it at 1. So if you want to cover that, I will do a short video like I did on the other trial tomorrow, because I can't stand sitting through these victim impact statements. But I'll do that I'll do that sometime tomorrow. But I'll be back at 11 p.m. Brandy, I think, will be live at 1 p.m. to cover the Laurie Shaver. Yeah, I think that's her name. The wife who buried her husband under the fire pit. And Jim Cox, member for 8 months. Get in bed with you. I'll pass, no offense. Well, we won't be sleeping if you get in bed with me, if you know what I mean.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
All
right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.